Good. We're probably waiting for Lady Justice Rose. Good. We're all set then. Mr. Howe, please continue your reply.
Yes, my lord. For the short adjournment, I was on the topic of the assertions that as the nature of Tunein's business and the comparisons that the respondents seek to make with entities such as Newsbin or Pirate Bay, and explaining why such comparisons were entirely unfounded. In connection with that, there was also some discussion of paragraph 201 of the judge's judgment, 200 of the judge's judgment, and whether or not there had been a challenge to those findings in the appeal. In fact, we do challenge the findings in that paragraph. It's in the grounds of appeal at page 19 of the core bundle. In particular, paragraphs 39 to 41, we followed through in relation to para 202 at 42. But our point is that the judge considered irrelevant matters and failed to consider relevant matters, which is to say the Tunein's positive evidence about its enforcement policies and terms, and so on and so forth, all of which he appears to have implicitly either not accepted or simply rather ignored. We followed that up in our skeleton argument at paragraph 100 on pages 68 to 69 of the bundle. Summarising those points, in relation to what the judge took into account that was irrelevant, the judge, when approaching the question of how Tunein had responded to complaints, confused two distinct matters, which I mentioned before the short adjournment. The first is the complaints about stations that are operating illegally or without a licence, in relation to which Tunein has its notice and takedown policy. And secondly, the claimant's assertions in this case, where they asserted that Tunein needed a licence in order to have category 3 stations, which is to say foreign stations not licensed in the UK on its platform, in relation to which, from the outset, Tunein took the position that no such licence was required. Now, nothing can be inferred against Tunein from the fact that it has taken the position, on the basis of the law as it understands it, that licence is not required for foreign stations on its platform. One can see that also from the correspondence. My learned friend suggested that Tunein had been given notice of stations to take down and had done nothing for months. That is not a fair representation of what happened. What in fact happened was that the claimants wrote to Tunein asserting that a licence was required to have a list of foreign stations on the platform, and Tunein's solicitors responded saying we don't think a licence is required for the reasons that we've explained in this appeal as well as below, which is that we say that there's no communication to the public by Tunein. And one can pick that up in the supplementary bundle at page 516. This is the first letter sent by solicitors for the claimants to Tunein on behalf of members of IFP at that stage. And they then explain the nature of their complaint after explaining IFP. They refer to the Tunein service at the bottom of the page and talks about that does. And then over the page, it said on page 517, a large number of the streams accessible through the Tunein service are not licensed for reception by members of the public in the UK. If BS investigates the licensed vision of a sample of the streams available, we set out in the Act by letter 846 simulcast stations and webcast services not licensed for reception in the UK. So that was the complaint, not that these stations were not licensed, but they were not licensed for reception in the UK. And that was said to be an infringement of Section 20, which is, of course, the very issue with which we've been concerned since. Those instructing me then responded to that at page 540 on the 5th of April, explaining Tunein's service, that it's a directory service providing links, and then obviously further describing the nature of the service. And they took the position in that letter, in brief, the essential position that Tunein has taken since, which is that there's no communication to the public by Tunein, by reference to GS Media and also Spencer. And there's the matter stood until July, which is the next page, page 543. When solicitors for the claimants responded to my instructing solicitors, disagreeing with them about the correct interpretation of Section 20 of the CJEU, and making arguments over the following pages concerning a new public and so on and so forth. And my instructing solicitors then followed up with a further response to this debate over the correct interpretation of the CJEU cases, page 546 and onwards, as one sees, to which there was then a further response, page 549, in August, again engaging with the arguments about that issue. So in those circumstances, it is not a fair presentation of the event in this case at all to suggest that Tunein got a demand to take down or to block the 800 or so stations and simply refused, and therefore showed it had no regard for the rights of copyright owners. On the contrary, the point that was raised at that stage in the litigation was an assertion that those stations were not licensed in the UK, not that they were unlicensed or behaving improperly. And in relation to that, Tunein took the position that it has throughout the proceedings that it doesn't require a license to provide its service in relation to those stations for the reasons we have explained. So the judge appears to have rather to have taken or considered that adopting a principled position in relation to those stations was in some way indicated a lack of regard for UK copyright, which is not at all a correct inference to draw from what happened, and nor is it right, as my own friend suggests this morning, this is an example of Tunein simply ignoring reasonable requests from rights holders or anything of that nature. It should also be added that in addition to that, shortly after that, from August onwards, Tunein, without prejudice to its position, took steps to geo-block the stations that were listed in the letter, which is dealt with in Miss Robinson's statement. Now, as for the relevant matters that the judge appears to have overlooked, Tunein provided extensive evidence to the court below, particularly obviously Mr. Justice Carr, concerning the positive steps it takes to ensure that copyright is respected and protected. And one finds examples of this at page 154 of the supplementary bundle in Miss Robinson's statement. And over the following pages, Miss Robinson set out what Tunein's copyright policies were. Page 155, the DMCA takedown notice procedure, and that continues over a number of pages, the DMCA process in detail, the 3 strikes policy, a section dealing with particular complaints made by Sony DMCA, which they also addressed, radionomy related takedowns as a particular service in the States that allowed homemade stations, in relation to which there were a number of takedowns, and the arrangements with Sound Exchange and so on and so forth over the following pages. And she summarises the responses taken in relation to takedown notices. On page 163, she moves on to other enforcement steps taken by Tunein and describes a number of steps taken in relation to that. And at page 164, she removes the response to the claims letter of 7th March 2017. And notes at the bottom of paragraph 77 that she was asked, after receiving the, in response to a letter from Bird dated April the 5th, Wigan State instructed to start legal proceedings. At that point, I was asked to remove away 146 stations referred to. And then she talks about doing that task, which was geo-blocking in April 2017. As it turned out, she then describes there are a number of stations that had to be reinstated because they had been wrongly included on the list and were unhappy about being removed. So our point in relation to this area is that the characterisation of Tunein and of its business is inaccurately described by the judge, and he didn't take into account the relevant evidence concerning the Tunein policies, but also, and personally for the moment, we submit that the way that it's presented to you, my learned friend, is also equally inaccurate and really not a fair characterisation of the position. It's also the case, in addition, that there was evidence in Mr. Straley's evidence that the claimant parent companies themselves, Sony, for example, has collaborated with Tunein on a number of occasions in relation to certain of its devices, which is hardly something one would expect to occur if it were really the claimant's position that Tunein was some sort of rogue entity or not respectful of copyright. Moving on in a related area, my learned friend made some comments on comparisons between Tunein and search engines. We have already made submissions as to why we say relevantly we do nothing different to a search engine. But it is also worth noting that my learned friend's assertion that Google, for example, doesn't provide direct links to streams of radio stations is factually incorrect. And one can see that in the supplemental bundle at page 504. This is a standard search for classical music radio. And one can see that it then throws up a number of searches. There are cards that we referred to previously. And underneath cards, in the middle of the page, there's Classic FM. The first result is Classic FM, listen live, classicfm.com. And then you can see underneath it in very small writing, the web page is classicfm.com/listen. So that appears to be not simply a link to the Classic FM website, but rather a direct link to the listen stream. If you click on that, it will go through. In addition, of course, one can see that it's got the very small letters "ad" at the start of that, which indicates that Classic FM has probably paid some form of advertising arrangement with Google in order to ensure that that result shows up. And one can tell it's not the link to the station itself, because the station itself is a couple of lines further down, Classic FM, the world's greatest music. So it's not the case that search engines generally do not link specifically to streams. Sometimes they do and sometimes they don't. The distinction that's being contended for, again, of course, accordingly simply collapses. We do things essentially when it comes to what happens, which is the provision of convenient hyperlinks linking to freely accessible information on the internet both operations are doing the same thing so far as is relevant to communication to the public. Moving now to the question of the issue of targeting. My own friend made a number of submissions about targeting, which in our submission were confused and confusing and inaccurate, mainly because they conflate two very distinct concepts, which is the concept of new public and the concept of targeting, which have completely different jurisprudential bases and operate in a different way in different aspects of the exercise of these rights. Now, first of all, though, my learned friend asserted that in relation to the streams on the Tunein website, that are linked to on the Tunein website, that the ordinary consumer was not going to have an inkling of whether some streams are targeted at the UK or not, from which he suggested that it followed from that they must all, those streams, be targeted at the UK. This is a non sequitur. In fact, the submission supports the very opposite conclusion and the very point that I made. As is established, the assessment of whether a website or any part of it or feature of it is targeted at the UK is assessed objectively by considering the position of the reasonable consumer, as the judge described in his judgment when summarising the principles at paragraph 16. In this respect, there's a clear distinction which we say the learned judge neglected to draw between the service which Tunein offers, which is a service of providing a platform by which users can find radio stations they might want to listen to, essentially a specialised search engine, and the radio webcasts by the radio station operators. Now, a reasonable consumer using the Tunein platform to find a radio station would correctly infer that the Tunein service, which is the provision of this handy way of finding stations, this index platform, is targeted at the UK, and we don't dispute that that service is targeted at the UK. However, the reasonable consumer would make no inference about any of the station operators that one could find or that he could find on Tunein. The fact that a station can be found on Tunein is completely neutral as regards where the particular stream of the radio operator or the radio operator's service is directed. All that one finds on Tunein is a way of locating that radio station and then clicking through to it. No reasonable consumer would assume that just because they can find the Slovakian national radio service, for example, on Tunein, this means that Slovakian national radio is targeting the UK. It is a neutral feature that simply says nothing. Now, my learned friend says, well, in essence, in his submission, he accepts it. He says that no ordinary consumer is going to have any inkling whether a particular stream is targeted at the UK or not. Well, we're quite clear that's because none of them are targeted at the UK merely by being on the Tunein service. Something extra would be required to indicate any particular intention of targeting by the radio station operator. Now, there's a further concept lurking in perhaps the judge's analysis, but also my friend's submissions, which is a suggestion that Tunein itself is targeting the stream at the UK. But that, of course, is a fallacious and circular proposition to make. Tunein does not provide the stream at all. It simply provides a hyperlink to it. If by providing a hyperlink to the stream, Tunein is communicating to the public, which Tunein does not accept, then of course it would follow that that communication, because it takes place on the Tunein website by Tunein, would be a communication targeted at the UK. But that depends on establishing that Tunein is in fact communicating to the public by providing a hyperlink, which depends on the application of principles in Svensson and GS Media. If, as Tunein contends, it is not communicating to the public by providing a hyperlink, then the question of whether Tunein is targeting a stream or not is irrelevant, and indeed a nonsensical question to ask in that context. Next, under the same heading of targeting, my own friend referred to some authorities on this issue. He started with a reference to CJEU, drawn from the respondent's skeleton argument at paragraph 30.5.1. Page 85 of the core bundle. And the relevant passage drawn from CJEU is the court has emphasised first the indispensable role played by the user and the deliberate nature of his intervention. The user makes an act of communication when he intervenes in full knowledge of the consequence of his action to give his customers access to a protected work, particularly where, in the absence of that intervention, those customers would not be able to enjoy the broadcast work, or would only be able to do so only with difficulty. Now, that's the principle that the respondents cite in support of the proposition that what Tunein is doing is communicating to the public, amongst other arguments, obviously. But clearly, when one looks at that proposition taking it its highest, it does not apply to Tunein, because Tunein is not playing an indispensable role in providing access to the streams of the radio stations. All of these radio stations are freely available and can be discovered by anyone readily with an internet connection using any standard search engine and listened to whenever anybody wants to. Nor is Tunein providing access to a protected work in circumstances where customers either can't do it in absence of that intervention, because of course anyone can, or where they would only be able to do so with difficulty. It is not difficult to access any of these stations. They can easily be found, located and listened to by anyone in the world who has access to the internet. Next, my own friend referred to the Raphael case, which is in the bundle of authorities at page 1956, tab 70. Oh, that's the wrong page number, I'm sorry. Oh, wait a minute. Yes, that is the right page number. And referring to paragraph 40, he sought to equate the use of the word directed at the top of page 1957 with targeting. He said that was really a synonym for targeting. That submission, in our contention, displays a basic error of principle. The concept of a new public, which is what the Court of Justice is directing here, is concerned with determining the issue of primary infringement, whether there's a communication to the public at all. The Court of Justice has established that there is no communication to the public unless there is a new public. In order to determine this, you have first to consider whether the second communication, the one that's said to be infringing, was addressed to a different public to the first. This may include a consideration, if there is a rights holder who authorised the first communication, of what the rights holder is deemed to have contemplated, or rather the audience the rights holder is deemed to have contemplated at the time that he authorised the first communication. So the question of a new public is considering the scope of the original authorisation of communication 1. And that, of course, depends on the line of CJEU cases, including Spencer, which provide criteria for deciding whether there's a new public or not. And in Spencer, as we know, the court deemed that the original public of the content that was made freely available on the internet in that case was the whole internet general public, so everyone in the world who could access the internet, from which it followed there could be no new public. So that's the role of considering the scope of people contemplated for the purposes of a new public. It comes in at the start of the process when one's trying to determine if there has been a communication to the public at all. Because if there's no new public, there's no communication to the public. Quite separate from that is the concept of targeting. Targeting only arises if there is a potential act of primary infringement. So one has first to establish, in the case of a communication to the public, that there is a communication and a new public. And then at that point, one considers whether the communication in question is targeted at a particular territory as a jurisdictional threshold. So in order to decide, for example, if there is a communication to the public by a radio station in Germany, whether that communication to the public is taking place in the UK, so constitutes an infringement of UK copyright, you need to consider whether the communication is targeted at the UK. And that involves the type of consideration that the judge described, which is the reasonable consumer, or reasonable member of the public, objectively viewing what is being provided, whether it's a website or something similar. And that's based on an entirely separate line of authority about targeting, described by the judge in paragraph 16, which is independent of and has nothing to do with the concept of a new public for the purposes of communication to the public. Apart from anything else, consideration of communication to the public involves considering different hypothetical people from the consideration of targeting. Targeting is directed at the recipient and what the consumer might objectively think. Determining a new public for the purposes of primary infringement communication to the public is a completely different exercise of deciding what hypothetically the rights holder must have been deemed to have provided the communication to when he made the first communication, or to have authorized the communication to when he made the first communication. That being so, it's not helpful in our submission to suggest that when the Court of Justice is talking about directing, or even using the word targeting in the context of determining a new public, that it is in some way invoking or considering the concept of targeting for the purpose of determining where the act takes place, because the two are completely independent exercises that operate on completely different principles. Now, the reason why these submissions are made by the respondents, as we perceive it, is because the respondents are attempting to justify the judge's decision to impose effectively a territorial limitation on the ratio in Spencer. And what I mean by that is the judge decided that when considering whether there was a new public, for example, when a stream crosses from Germany to a listener in the UK, that Spencer hadn't really considered the possibility of internet transmissions or content being available to everybody, and that therefore one could infer that there was a new public because the original communication could only have been contemplated, in the case of, let's say, a German radio station, to be directed to the German audience. The problem, and that one can then say, or perhaps one relies on that by way of analogy on concepts of targeting. However, the problem with that analysis is, as I say, firstly, targeting is nothing to do with the determination of a new public. It's a separate concept operating at a different point in the analysis. It's to do with the location of the infringement once you found there's an infringement. The second problem with that approach is that it is, in our submission, completely contrary to the very clear ratio in Spencer, which established that subject to the GS media exception, the public to whom communication was made when material was posted with the consent of the owner onto the internet was all internet users. And one finds that in the bundle of authorities, it's tab 19 at page 163. Paragraph 26. where the court says the public targeted by the initial communication consisted of all potential visitors to the site concerned, since given that access to the works on that site was not subject to any restrictive measures, all internet users could therefore have free access to them. Then after explaining in those circumstances it must be held, where all the users of another site, etc., at issue being communicated by means of a clickable link, could access those works directly on the site which they were initially communicated without the involvement of manager of the other site. The users of the site managed by the latter must be deemed to be potential recipients of the initial communication, and therefore as being part of the public taken into account by the copyright holders when they authorised the initial communication. Therefore, since there is no new public, the authorisation of the copyright holder is not required for communication to the public, such as that in the main proceedings. Now, as we know, that was qualified in relation to illegally posted content or unauthorised content in GS Media, which is how the GS Media issue arises. However, in our submission, the ratio in Svensson is clear and unambiguous. What it means is that if there is material lawfully posted onto the internet, which is freely available, there can be no new public by hyperlinking to it, and therefore there is no communication. And that is not undermined and cannot be gainsaid by trying to draw false analogies with concepts of targeting to try to cut down the scope of the Svensson ratio. Targeting has nothing to do with this issue as properly understood. Targeting in the sense of a jurisdictional requirement, entirely separate concept. And similarly, in Soulier, which my learned friend also referred to, getting a reference for it. It's at tab 72. Page 1979 of the authorities bundle. At page 2006, in the paragraph my learned friend referred to, when describing the ratio of Svensson, the court said that where an author had given prior explicit and unreserved authorization to the publication of his articles on the website of a newspaper publisher, without making use of technological measures restricting access to those works from other websites, that author could be regarded in essence as having authorized the communication of those works to the general internet public. Now, in those circumstances, given the unequivocal nature of those holdings by the Court of Justice, in our submission there's no room to try to cut down the effect of those holdings, as the learned judge did, by imposing a territorial limitation on the scope of the consent, when what one is concerned with is linking to internet sites which have no restrictions on access. The general internet public is the public for the purpose of that first communication. It's also, in our submission, not credible to suppose the judge that the Court of Justice overlooked the possibility that there might be limited licenses in relation, territorially limited licenses in relation to publications. There's no indication at all anywhere in the Court of Justice's reasoning that they considered territorial limitations in relation to licenses to be of any relevance to this effective deemed policy finding as to the freedom to access material that was available lawfully on the internet. And of course, it would be completely inconsistent with the policy underlying those decisions to impose such a limitation, because as soon as one were to do that, one would be effectively imposing substantial barriers preventing people from being able safely and lawfully to link to any site that was outside their particular jurisdiction. So there's not a hint that the Court of Justice was concerned with trying to limit the scope of that doctrine by reference to considering whether there might be some implied limitation by reason of territory or otherwise. And indeed, it would have largely denuded those judgments of any practical effect if that had been the approach the court was going to take. Turning to the other operators in different cases that my own friend suggested were really no different to Tunein. In our submission, these contentions that there's no real difference between these other operators and Tunein in the cases that are reported are untenable. The first example he gave was the film speculator case, which we've looked at, and I won't turn up. It's in the Bundle of Authorities at tab 74, page 2049, but it concerns, as we know, the selling of a multimedia player that had built into it hyperlinks that were designed primarily, although not exclusively, to access infringing material, and a large portion of that material was known to be infringing. In fact, the device was sold, as is recorded in the judgment, on the basis of advertisements, or perhaps it's the Advocate General's opinion, but on the basis of advertisements that it provided free access to things that you would otherwise have to pay for. Furthermore, the links were not easily accessible without the device. It was a classic case, where without the intervention, the content in question either could not have been found at all, or only with difficulty, whereas the provision of the multimedia device provided a user-friendly way for people to find infringing material that they otherwise would not have been able to find easily or at all. Similarly, Ziggo is the case about one of the cases about Pirate Bay, and the Pirate Bay technical procedure. Again, we have looked at this before, but I think it's tab 22 of the bundle, Joint Bundle of Authorities. But Pirate Bay, again, is a completely different type of technical service to the pure hyperlinking cases or simple hyperlinking cases. Pirate Bay provides an index by which people can obtain, if I've got it right, the BitTorrent files. Having downloaded the BitTorrent files, those can then be used to assemble copies of infringing works. So Pirate Bay, firstly, the object of the exercise, as far as Pirate Bay is concerned, is again to make available large quantities of infringing material. That's a known purpose of the system that Pirate Bay forms part of. Secondly, Pirate Bay isn't simply hyperlinking to content freely available on the internet. It's providing the tools by which, it's an essential part of a technical process by which people can obtain and assemble from the swarm, which is so generally from the internet, infringing copies of material. So it is, again, very different indeed to the type of case with which we're concerned and with which the court was concerned in Svensson and GS Media, which is the provision of hyperlinks to websites that are not subject to restrictions that anyone can freely access. A similar point arises in relation to the case of Newsbin. Newsbin was concerned with another similar technical process to Pirate Bay. It was to do with the Usenet system, whereby what Newsbin was doing was was providing and indexing copies of Usenet files, and the detail is contained in the authority. It's in the authorities at tab 52. This is another example of the defendant in that case providing an essential component of a complex system by which infringing material was provided. It is not remotely like a hyperlink case, or doesn't raise the same considerations. I should also mention, incidentally, that in the Ziggo case regarding the Pirate Bay, there's a reference to what are called magnet links. But these are not, lest anyone think otherwise, ordinary hyperlinks of any sort. They're referred to in the judgment and not very well explained. But they're an entirely different type of link, which is functionally equivalent to providing a torrent file. It's not a case of simple hyperlinking to material on the internet. Dramatico similarly also concerned Pirate Bay, that's tab 33. FAPL is of course a pre-Svensson case, and it doesn't appear to be, although it's not necessarily very clear from the report, a case in which they were freely available websites. That's at bundle 33, sorry, tab 33, page 631. No, I'm sorry, it's tab 35, page 681. Obviously, a decision of my Lord Lord Justice Arnold, and it concerned a service called First Row Sports, as one can see from the holding H1. And First Row Sports, it appears, provided, moving forward to page 686, from its website, it provided links to what are called third-party streamers using a number of user-generated content websites. And it then goes on to describe that process. So First Row is providing hyperlinks, but it appears not to generally available websites or sites that can be obtained with ease. Indeed, the whole point of First Row was to enable people to put up illegally obtained or copied or streamed content into the user-generated content websites. And then First Row provided, as it were, the secret path or semi-secret path to enable those easily to be accessed by users. So again, not an example like the present case of straightforward hyperlinking to sites that are freely available on the internet. Similarly, in relation to the Paramount case, which is tab 44, at page 1004. This concerned, as one can see from the holding, two websites located at Solar Movie and tubeplus.me, so Solar Movie and Tube Plus. And turning to page 1007, it says that the Solar Movie and Tube Plus don't provide access to downloads, and 99% of the content accessible via each website is likely to be protected by copyright. This is paragraph 5. And the mode of operation of the websites is broadly similar to that of the First Row website. And it explains in paragraph, the Lord explained in paragraph 6, users who wish to access content provided with a number of these links in response to searches. Typically, clicking on a link enables the user to stream and view a stream of chosen content on an embedded player. And some also provide access to downloads posted by one of a number of third-party websites. Some require a person to become a member, others do not. At least in the latter case, the host sites tend not to be searchable. So again, it appears that this is another example of a service which firstly was providing access to a very large quantity of known to be infringing material, and secondly, that it was a case in which the websites to which access was provided by the links was not something that could be achieved either at all or without difficulty, without the intervention of the two linking sites. So again, not a case at all similar to the present case, which we say is essentially in the territory of Svensson. While I'm on that report, there's also a useful reference to the facts in Svensson, which provide some extra colour and some explanation of the type of service provided by the defendant in Svensson on page 1010. Now, at this point, in relation to Svensson was pending, and at paragraph 15, my Lord Justice Arnold describes a bit of detail about the retriever defendant service. Provides its services to about 3,000 subscribers. The media monitoring service involved retriever searching the internet using agreed search words so as to inform the subscribers to how it's been reported in the media or how specific issues have been handled. The results of the search were sent by retriever to the subscriber by an email which included links to relevant articles, that is to say hyperlinks on which the articles were available, together with so-called link tails, which included a few words from the articles in question. The subscriber could also review the search results by logging onto the retriever's website. The subscriber so requested and paid an additional fee. The search included a search of a particular database. The search service comprised a search facility on retriever's website. The search included a search of the media archive database. The search result was presented to the subscriber in the form of a list of links. Claiming contended that each of the 13 articles had been accessed via such links by one of the retriever subscribers who used the search function. Now, the reason I mention that is because that makes it abundantly clear that the Court of Justice in Svensson cannot have been confined to considering it as merely a domestic case of an argument between some journalists, a Swedish journalist and a Swedish-based media site. It's clear that what Retriever was doing was providing a very large number of links based on searches to its subscribers. It also had a facility to search on its website to the same effect. It is improbable in the extreme that when the Court of Justice was approaching that case, it viewed this as simply being a domestic matter, and therefore its reasoning could be confined by reference to an expectation that the licensing question was only concerned with issues within a particular jurisdiction. It is apparent from that the Court of Justice was considering a large number, potentially a very large number of hyperlinks spreading across every jurisdiction regardless, and therefore the ratio is not restricted in a territorial way, as the judge found, and my own friend contends. Briefly in relation to finishing off the topic of limitations or targeting, it follows in our submission, therefore, that there was no proper basis on which the judge could attempt to cut down the clear ratio in Svensson by imposing the territorial limitation, and therefore the reasoning in Svensson was binding on the judge as regards the Category 3 stations. The only further step that needed to be taken was to consider whether the principle in Svensson applied not only to material which was posted on the internet with consent, but also equally to material that was available on the internet lawfully, for example, under a compulsory licensing, or because, for example, it was a permitted use under Article 5, commenting on current affairs, review or criticism, and so on and so forth. Since the principle in Svensson, we say, cannot sensibly be limited merely to cases where express or indeed implied consent is given, it must apply to all lawful content that's available. Otherwise, the principle would be unworkable. It is designed to ensure that hyperlinks can operate properly, that people can freely share information by using hyperlinks. If one were to introduce an idea that it wouldn't apply to material which, even though legally available, was available without the express consent or implied consent of the copyright owner, then the whole purpose of Svensson, or large part of the purpose of Svensson, which was to ensure freedom of expression was properly protected, would be severely undermined. Connected with that, my learned friend also referred to the question of equitable rights regimes and suggested that some different approach should be taken in relation to these or statutory licensing regimes. In our submission, that's not correct for the reasons that I've just explained. If one starts to introduce a limitation on the Svensson principle in that way, then the protection provided by Svensson to users of the internet to exchange information is very substantially reduced, and it becomes extremely difficult for anyone safely to link to a hyperlink outside, for example, their particular territory. One cannot know, if you're a journalist posting a hyperlink to, let us say, Le Monde, whether the journalist in question has provided a license to Le Monde to publish only in France. It's quite possible that is so in relation to much content on the internet. It wouldn't be surprising if it were so. But if one were unable to hyperlink in those circumstances, then Svensson would largely be defeated, and one would be unable safely to hyperlink to anything very much, certainly very little outside your territory. The same related point in connection with this is the question of reciprocal rights. My learned friend suggested that it was possible that in relation to certain collective management organisations, they might or might not have reciprocal rights. Now, the generality of the provision of reciprocal rights was not, I think, addressed directly in the evidence, but it is the case that many collecting societies provide reciprocal rights across boundaries. Certainly the case with our domestic collecting societies. The main ones have reciprocal rights covering a number of territories. It's also true of many other collecting societies. But therefore, another problem with suggesting that one should assume, or as a user you have to assume, that there may be some territorial limitation on the rights granted because they've been granted under some scheme in another country, is that may well not be so. There may well be some form of reciprocal arrangement that would entitle the operator to be providing, for example, a station in Germany providing services in England, which is, so one cannot simply assume blithely that there must be some form of compartmentalisation or division of the world into little jurisdictions for the purpose of hyperlinking. It's impractical and makes no sense in our submission. That brings me next to the question of GS media presumption, which I can address briefly. The respondents have a very peculiar interpretation of the GS media presumption. We say the GS media presumption is simple, which is the question is whether the person knew or ought to have known that the material that they are linking to has been published illegally, either without consent or otherwise. We say that that test is easily understood and it can be applied. First of all, you consider whether the person knew they were linking to illegal material. Secondly, if they did not know, whether they ought to have known. And the only difference between the profit-making linker and the non-profit-making linker is the presumption. The respondents wish to extend this presumption to being a question of whether the person knew that the material that they were linking to was protected at all. Now, that would render the potential scope of GS media extraordinarily wide and almost entirely irrebuttable, because a vast proportion of the material that's published on the internet is subject to copyright or other rights protection. Therefore, in many cases, if an issue were to arise, it would be almost impossible for anyone to say, well, I didn't know that it was potentially subject to copyright protection, because most of the material, or for a very large portion of the material, is. That, we say, is simply a misinterpretation of the GS media presumption and would make it unworkable and also an extraordinarily broad doctrine. My learned friend also submitted in this context that we were saying that if we prove we didn't know, that was enough. We don't say that at all. That's not our case. We say that the first part is the stage is to show whether you knew or not. If you are for profit, you have to show that you didn't know you were linking to illegal material. But that's not the end of the inquiry, because the next stage is to inquire whether the linker ought to have known that the material was illegally published. So it's not enough simply to say you don't know. You also have to show that you should not ought to have known, which involves an inquiry of whether if you had carried out this, that, or the other inquiry, you would have discovered this, that, or the position in relation to consent or lack of it. Also in relation to this, my own friend suggested that we proceeded in a generalised way and did not seek individual findings in relation to the Category 2 stations. That is incorrect. The Category 2 stations were addressed individually in the evidence. One finds, for example, in the supplementary bundle at page 184, 187, Mr. Straley's evidence. Starting at 182, one can see that he's provided what they believe the position to be. In relation to each of the sample stations. Including the Category 2 stations on 182 to 183. And then he continues to explain the steps they've taken in relation to each of the stations. There was similar evidence from the claimants in relation to each of the sample stations as well. But it is not the case we agreed to proceed by way of generality. This is not the way that the trial was structured. The proposal for having sample stations to ensure that these factual matters could be addressed in an organised way. The problem is that the judge decided to deal with the matter at the level of generality, which was, in the circumstances, didn't engage with making the correct findings as to the status of the Category 2 stations for the reasons I've explained, or as to Tunein's state of knowledge in relation to them. Next, the PROAP. The referent referred to the respondent's notice, suggesting that another way of finding infringement in relation to the PROAP was that it was addressed to a new public. This is, we say, simply another way of conflating the communication right with the copying right. The presence of a recording function cannot logically make any difference to whether or not the transmission of the stream to the user by the station by the operation of a link activated through the PROAP is or is not a communication to the public, any more than, as I said, turning on a cassette recorder when listening to a radio broadcast can change the nature of the broadcast. It remains a broadcast. The fact that one is recording it is simply an additional activity that may or may not be covered by copyright, but is neither here nor there. One other point of detail in relation to this is the PROAP itself. In the supplementary bundle at page 204, did not included metadata sorry, I've got a false reference. Sorry, page 142. I don't know why I got the wrong reference. Page 142 of the supplementary bundle, Mr. Godsay's evidence. He explains in paragraph 57 how the record function worked, which is that the the bytes relating to the audio and the stream read and then written to an encrypted file, the amount the listener could record was dictated by the user, subject to storage remained available on their mobile device. The recording user interface listed each recorded file as a single block of time without any description of the content other than the index station name, and the user could choose which recording they wanted to play. Any copies made as a result of the user using the record functionality on their mobile device was stored in the mobile device's local memory, could only be accessed within the app. No mechanism with which to export the recording outside Tunein Radio Pro app, since they were encrypted such they could only be played within the app. So it was a confined, non-exportable recording, recorded as a single block of time. So any recording one looked at in the app would be recorded as a block of time. The metadata when you played the block would show the song playing as you were playing it, and you could intelligently skip through the block to find items, but it was not in any sense equivalent to or similar to a device by which you can pick particular recordings and choose when to listen to them. Simply, as it were, a block recording of a chunk of radio through which, if there was metadata, it was possible to skip if it was available and if the skipping function worked. Next, in relation to the GS media presumption, I already addressed the way the judge referred to the warranties given by the radio stations, and my own friend sought to support the judge's view in relation to warranties. However, in our submission, the question is, what else is an operator, such as Tunein or any search engine or many other web operators, to do when it comes to determining rights? Other than to ask the people who are providing the material to them or making it available to them or to which they are linking to confirm that they have the relevant rights. It's not feasible for an entity like Tunein or many other similar operators to do much more than seek appropriate warranties from the people with whom they are dealing. It is, short of sending in an investigator to every 100,000 radio stations, there is no reasonably practical way of establishing a reasonable assurance that another party on the internet has obtained the relevant rights without relying on warranties. It's a normal and sensible commercial approach to dealing with this type of issue, and in our submission there's no basis on which one can say the warranties aren't important, or that Tunein considered them to be unimportant, or that somehow ticking a box doesn't represent the accepting of terms and conditions of warranties. But all of these things are normal commercial behaviour and the way in which reasonable parties on the internet operate in order to ensure that they have established the necessary assurances that the people they are dealing with have obtained the necessary rights to provide what they are providing. Well, as one other point in relation to the Pro App that I should have mentioned is, of course, it's also the case that the recording will have been used within the Section 70 time-shifting exception on a number of occasions. We don't have figures for how many people use the copying process within their domestic premises for time-shifting or otherwise. But it also follows from that that it is not inevitable that copies made using the Pro App will have been infringing, even if the copies included some copyright material. My Lords, I'm nearly done within my time, or just slightly over my time. There are a few minor further points to make. In the course of my friend's submissions, my Lord Justice Arnold raised the question of whether it matters that the link provides direct access or not to a work for the purpose of deciding whether or not it was a communication to the public. And the context for this discussion was in relation to the work Lewinsky, which is, I think, at page 3191 of the authorities bundle. paragraph 7.8.33. And this was a discussion of the making available right. And the authors there explain that the work must be made available in such a way as members of the public may access them from a place at a time individually chosen by them. The element of individual choice refers to the on-demand situation, excludes the making available right any exploitation way of offering at a specified time, predetermined programme for the reception by general public, such as broadcasting of radio or TV programmes by judicial means, or through digital networks such as webcasting, simulcasting, simultaneous and unchanged retransmission of traditionally broadcast programmes over the digital network, real audio, internet radio, etc. And they go on to describe the various types of services, which obviously would include any of the radio streams as which we're concerned here. In all these cases, the user is dependent on programming and cannot individually choose the time at which he or she wants to access a particular work. Examples of the on-demand situation are websites that offer a choice of musical works, cinematographic works, scientific articles, other works for access at any time during which the service is offered, to be chosen by individual members of the public from the place chosen by them. The point of that is that we also, in our grounds of appeal, have challenged the judge's conclusion in the judgment of 111, where he decided that, aside from all the other arguments, it was not necessary for the hyperlinks that Tunein provides to provide direct access to particular works. The point being that Tunein does not provide direct access to any of the claimant's works. What it provides is access to a stream, which has a changing body of material, some of which may be talking and some of which may be adverts, and then some of which is likely to include at various points the claimant's works. That is not, we submitted, and the judge didn't accept this submission, but we submit he erred in this. That is not, regardless of any other consideration, providing a hyperlink to a stream is not the provision for making available of the works contained within the stream, because it is not within the concept of making available. The user cannot access any of the works in question on which the claimants rely at a time or in a place individually chosen by them. We've addressed this and given references to the passages from Spence and GS Media and Bestwater in our skeleton argument at paragraphs 47 and 48, where we note that in all three of those authorities, the reference was to direct on-demand access in Spence to literary works, in GS Media to photographic works, and in Bestwater direct access to a film. In none of the cases was it the situation as it is here, where no direct access to any work is being provided, simply to a broadcast stream. The direct access is to the broadcast, not to any work within it, and therefore none of the works within it is being made available, even if we were wrong on all the other points that we have made. Lord, the last topic I was going to address was the question of departure from EU law. I've already addressed this previously. I don't propose to repeat myself. Two short points. Firstly, as regards the scope of our grounds of appeal, we challenged in our amended grounds of appeal the hyperlinking of the hyperlinking acquis of the European Court of Justice. Clearly, in order to challenge the hyperlinking acquis, we needed to challenge the principles on which the hyperlinking, the question of whether hyperlinking formed communication to the public or not, was determined. And that necessarily involves engaging with the process by which the European Court has analysed hyperlinking, which is to say how they define communication and how they define public. So we respectfully submit that the case we have put forward is squarely within our grounds of appeal. Secondly, as regards GS Media, as you know, we advanced an alternative case, neither where the court were not prepared to reconsider the principles that the EU court has applied to communication to the public generally in the way that they then are applied to hyperlinking. But nonetheless, the court should not follow GS Media because it's inconsistent with basic principles of intellectual property, notably by importing concepts of secondary liability into what should be a matter for primary liability, and that therefore, accordingly, the European Court should, in GS Media, instead of establishing the test that it did based on knowledge or presumed knowledge, should have simply answered the point by saying that whether or not hyperlinking to a legal material tracks liability or not is a matter for secondary or accessory liability, which is in turn a matter for the member states' courts, the individual member states' courts, and not a matter covered by the European law. My learned friend said in relation to that, if one were not to follow GS Media, it would mean that GS Media had mitigated Svensson, and therefore he would be in a better position, or rather his clients would be in a better position, because it would then be clear that we had committed primary infringement. That shows a misunderstanding in our submission of Svensson, in that it proceeds from the assumption the judge's territorial limitations in relation to new public in the case here, the present case, were consistent with Svensson. But of course we contend that they're completely inconsistent with Svensson, and therefore the answer in a case of linking to unauthorised material is to consider only secondary liability, and that no question of primary liability arises. Because if one removes GS Media, then it follows that the initial publication is to the whole world, accessible to the internet, and therefore there can be no new public by linking to any material freely available on another website, whether it was published consensually, illegally, or not. My lords, finally, just to summarise, there was my learned friend's cri de coeur, as he himself put it, which was to the effect that somebody must be doing a restricted act, therefore you should find that there's a restricted act. That, in our respectful submission, is not an argument at all. It lies in circularity. The question is whether what Tunein is doing based on the relevant authorities constitutes a communication to the public. If it does not constitute a communication, or Tunein is not otherwise liable, for example, via accessory liability, then Tunein doesn't require a licence and isn't required to pay anything. Saying simply that somebody ought to be paying something is not in our submission an argument, but is revealing of, we say, the mindset of the claimants, who appear to take the view that somebody ought to pay, because what we're doing appears to be something that we ought to be paying for. In other words, that's not an argument based on principle, even if it is a cri de coeur.
Thank you.
Those are my submissions.
Thank you, Mr. Howe. Lady Justice Rose?
No questions from me.
No. No. Well, thank you both and your instructing solicitors and juniors very much for those submissions. We will take time to consider judgments and let you have them in the usual way for typographical corrections. After that, please agree the form of order, any consequential matters and costs. If you're unable to do so, those matters will be determined in writing, and you should exchange written submissions within a reasonable timescale. If there's any disagreement about that timescale, we'll obviously decide it on paper. That concludes these proceedings, as I say, with thanks to all the lawyers acting in the case. Thank you.